have assembled. Well, that is retrospectivity or prospectivity. Lord, my submissions are not following. Lord, A. Lord, India Cements have held the field since 35 years, Lord, and parties have bona fide, under the law applicable at the relevant point of time, adjusted their affairs accordingly.
Yes.
Lord, difficulty with the mineral sector is this, Lord. Lord, mineral is essentially used, Lord, in every core sector of the economy. It will have direct impact on the economy of the nation. We are not, Lord, on individuals or companies or individual states. Lord, core industrial sector, Lord, especially critical to infrastructure sector, Lord. Almost all industries, directly or indirectly, are dependent on minerals. For example, for steel, you need iron ore. For aluminium, you need bauxite. For generation of electricity, almost 68% generation is through coal, which is again a mineral.
Yes.
Now, industries, whether it is public sector or private, cannot absorb the sudden rise of past years itself. It will have to pass it on. Now, kindly allow me to give an example of electricity. Electricity, the coal had a particular price, which was priced at the prevailing law at a given point of time, based upon which the respective commissions have framed their tariff, based upon which the consumers have paid. Now, the serious question now would be, suppose the generating company or the distribution company or any company concerned with the generation or transmission of electricity using minerals were to pass on, this additional past burden, can it be passed on to new consumers? Because all old consumers have gone, they have paid respective charges as per law. And now we can't ask them to make the payment.
Yes.
The moment electricity is affected and the moment the basic input like bauxite or iron ore etc. is impacted, necessarily it will have a cascading effect, and the effect will be felt actually by the common man. Now, there are several domestic contracts entered into, several international contracts entered into, based upon the law prevailing then, and every contracting party was justified. In choosing their commercial bargain based upon the law prevailing then, international contracts, national contracts, your lordships are aware, some of the contracts are such where one of the contracting party is always wanting a way out of wriggling out of the contractual obligations. They will use this, my lord, that now an additional burden, now the financial have changed. And they will cite, my lord, if there is a provision, my lord, in the contract for change in law, they will cite it. If there is no such provision, they will not be able to cite it. They will find out some other way that now it's not commercially viable for us to continue with the contract. And would lead to multiplicity of, my lord, litigations which we are unable to, my lord, comprehend at this juncture. Commercial contracts and commercial treaties, domestically and internationally, would be impacted. In every industrial, I'm sorry, the burden would eventually go to the common man, whether directly or indirectly. He will be the person who will bear the burden because no industry can absorb this. For example, we made a rough estimate only for the public sector undertakings. This is rough and ready, it is still the process of calculation is going on, but the approximate demand which the only PSUs are expecting would be somewhere in the vicinity of 70,000 to 80,000 crore.
Now, Mr. Solicitor, what was the prevailing interim arrangement during the pendency of these matters broadly?
There are several categories of cases. In some cases, the state government, the High Court, quashed the order respective of legislation of the state government. Like Orissa, and there is no stay. And they have never raised any demand for 35 years. In some, there may be some, either the law was upheld and your lordships may not have granted stay, so some have paid. Some may have paid under the interim order of the court. My difficulty, just I'll not name the PSU because this is also a listed company in the stock exchange. But in one of the big public sector undertakings, the potential demand which we have calculated is 3 times the net worth of the company. But for obvious reasons, your lordship would know, I am not naming that PSU, but a Maharatna PSU, a good, sustaining, successful, and financially fully viable, ongoing public sector undertaking. This would be the position with many public sector undertakings and perhaps most of the industries, if they have to absorb.
Broadly speaking, just to understand your submission, your 53 points you have understood, but now we have to go by also a nuanced approach on basis of what was the interim position for all these years. So as you said, some where the High Court has quashed the legislation and there is no stay granted by this court. There is no stay granted by this court.
I have a suggestion.
Some where the law was upheld and they have paid. Third, payment.
Only Bengal is the only example.
Bengal is the only example of? Right, yes, sir.
Lord, what I am suggesting is, not subject to appealing to your lordship's conscience, Lord, because this is ultimately, as your lordships have said, Lord, not a jurisdiction under 142, a part of the judicial statesmanship. Lord, what I am suggesting is,
you're also conscious of the fact that the states do need revenue and funds.
no, certainly, Lord.
And also that, as Sister Nagarna also mentioned in her judgment, where the levy was set aside, Parliament actually validated the levy. So that was also the intent of Parliament that the states must have.
That was not in 90s, but we are not after 90s. What suggestion I am, the suggestion is, we may not go into the state-wise enactment and what happened. It's not possible. In some states, 1 or 2 states, the amount may have been paid because of the no interim order passed by your lordships to the respective state government. My lord, your lordships may consider neither the state may demand any further levy retrospectively, nor the private parties or PSUs who have paid would seek any refund of the money.
Just one second, let me just.
This balances equities on both sides. I'm sorry, my apologies to the lordship.
So suggesting there should be neither demand nor refund.
No refund, yes, not equity.
So in other words, what you are really saying is make the judgment prospective subject to the condition that whatever has been paid will not be recovered.
Will not be demanded as a refund by anyone, by the private parties who have paid.
It can't be refunded anyway because they have succeeded now. The states have succeeded. Therefore, so what you are saying, we get the point that no recoveries for the past. And at the same time, whatever has been paid under the interim orders will rest where it has been paid. If it has been deposited, it is gone by the state. You got your point.
Another worrying factor would be this. The lordships are aware in MMDRA we had an amendment in 2015 where the regime of auctioning came. While participating in the auction, the respective bidders also calculated the price structure and the law prevailing at that point of time, and we genuinely apprehend several litigations on that front.
What you're saying is that when to bring finality and some certainty in industry, in the affairs of the nation, that we should really ensure that there is no further litigation and therefore adopt a gold standard which will ensure that it will sort of from here on now, there was an uncertainty in the law for 35 years. Subject to, of course, Kesharam, it operated. Of course, Kesharam didn't operate only in the context of West Bengal. This is the decision of the Supreme Court.
Nonetheless, my learned friend will have to say something on that. Wants to say something. But India Cement is 7 judges. Kesharam is 5 judges. It did not and could not overrule. Ultimately, yes, but
it was oblivious to Kesharam.
I'm not saying that. It was not. It was cited.
But we have been crafted. We have not dealt with whether it was a typographical error. We went into the first principle.
Even if you go by Kesharam, 20 years have passed by.
So we have to also
Kesharam is 2004.
We have to also be guided by the fact that we have construed now the matter's first principle on first principle, and we have upheld eventually the conclusion of Kesharam.
But Kesharam is also 2004. So, when your lordships, would your lordships consider being assisted with 2 judgments? I have cited some 50 judgments in my note. My note contains. Note is circulated.
Yes.
I just
Page 12 of your compilation.
Yes. One is synthetic chemicals.
Yes.
Inter alia. These are the 2 I can immediately cite. 1990 volume 1 SCC 109 and 7 is Somaya Organics. That is both are constitution bench. Yes. In my note, your lordship would find it at page.
All the paragraphs are 89.
My para is page 22 in synthetics chemicals. I have quoted the relevant there.
Para is 89.
Yes, which is quoted by in my compilation at page 22. Somaya is 2001 5 SCC 519. Synthetics is 7 judge bench. Somaya is 5 judge bench. And there, para page 51, 59, 259, I have quoted all the relevant para. Para 27.
Okay, got it. We have website.
And when 2 to 27, right?
Let me look at now.
Itself retrospective.
Investment.
Itself retrospective.
Yes.
Investment itself not 35. The rising itself retrospective. Immediately followed
It would have not only domestic but international economic impact on the country.
I'll take 5 minutes. Just one thing. Let me add any others.
I may note it to M.
But broadly, I can see, so instead of, we don't start going on to note at this stage. We'll just, can tell us what broadly.
What is it, the multipolar impact on many. Multipolar impact.
Multipolar impact.
So there are several things which are not visible before the court. So if mines and minerals are the spinal cord of economy today, there are many legislations which have happened later, many arrangements made later. So they interact on so many things which would have happened, which did not come into the reckoning of the court for good reason while the court went into entries. Therefore, I think that will be an important factor because the mining sector is impacted, the entire economy is impacted. From nanotechnology to healthcare. I mean, it's like that. And in my note, just only 2 paragraphs, Lord should just make a look at it. It's in volume 2M. Paragraphs 2, 3, 4, and 5.
Let me just go on the lighter side. I have not done what I should have done. Just struck me. Ever since you took over as AG, I should have maintained a little booklet of your aphorisms. Multipolar impact is what I have now got from nanotechnology to healthcare.
Yeah.
The latest judgment is also the Chief Justice judgment yesterday.
Judges do maintain their own little bags.
Sir said, the perspective, yesterday's judgment is the Bar Council case, Lord. I read in the paper for that.
Council cases,
Only saying, the Lordships have said yesterday, in respect of some other case, which is Bar.
Lord, right from Kupalan till this, Lord, the word which catch my attention was that this is a 142 jurisdiction conferred upon the highest court of the country only.
Seni has also made his point.
There's only 5 minutes.
And the test is the judicial statesmanship. When you know that economy will be impacted.
I need time to press page 182, just keep that open, easier and fast, after the submission. I would read. 182 has all the quotations. But the first point is we fully endorse these Solicitor General's comments, plus his observation. Second is that my submission is your Lordship will not make it state-specific, specific. Your Lordship is deciding prospective overruling or not. The acts will fall on this side or that side, subject of course to no refunds and no claims. That's a fair thing. Now, what I have done is perhaps stating the obvious, but giving it some judgments which state the obvious. Your Lordships have held repeatedly with us. First thing is that this India Cement, not only India Cement, but 5 judgments. First is India Cement itself, para 35, 36. Prospective overruling in the mining area. Second is synthetics, already mentioned, para 89. These are in my note, which is in your bunch, at page 184 onwards, 182 onwards. Third is Belsund. These are the same, no refund, no recovery. Belsund, sugar is all the constitutional benches, 7 judges, etc. In para Belsund 112 and 113.
Give us the citation of Belsund.
Yes. Belsund is 1999, 9 SCC 620. And the relevant paras are 112 and 113, Constitution Bench.
Okay.
Synthetics, my Lord knows, is 89 para number. Yes, in India, Cements is 35, 36.
Yes.
Then was a interesting judgment is Somaya Organics Constitution Bench.
Given us the citation also.
Yes.
And we got the
2001.
The 5 SCC 511, para 27.
519 was. Para 27.
22 to 27.
Yeah, but the crux I underlined in para 27. Now there is in commercial matters, just keeping in mind that your lordships have innumerable high courts and tribunals in the country following India Cements for 35 years. In a much lesser context, the hiatus between Bhatia and Balco in the arbitration field, which only got 5 or 7 years. 10 years? 10 years.
8 years.
In that context, in para 197, the citation of Balco is 2012, 9 SCC 552, a constitution bench.
Okay,
Made it more prospective than even asked for. It said arbitration agreements entered into after this date.
Anybody else? Mr. Ladha?
But I just wanted to add something.
Give a note.
But I wanted to add something, and I promise not to cite any judgments.
Yes. Mr. Ladha, can you just get back? Karan. Yes, Mr.
As we always say, sometimes for certainty, the law is more important than purity. The reason is for people plan their affairs. Just to add to the width of the canvas of where the judgment is operating, I'm not for a moment suggesting that anything other than what the solicitor has suggested, i.e., no payments, no recoveries, and no refunds. So the situation as prevails today will prevail. Just to underscore the need for this kind of an order, I want to give your lordship an example. One of the petitioners before your lordship is Mahanadi codes. Mahanadi, one of the history is these lands were acquired by the center from the states. These are coal-bearing lands. These lands were acquired, they were challenged, the Supreme Court upheld the acquisition of land around 1950s. And then the problem arose, the government said, you are not paying us anything, you take it away our coal. So payment is fixed under the law in lieu of royalty. Now this is a complex arrangement between the state and the union of how this mineral wealth is to be shared. Then in 2004, Orissa government came with the law. The High Court following India Cement struck it down, whether it should or should not have struck it down, whether it should have followed case around another story. But the fact is, he relied on India Cement and struck down the law. And today, if this company is asked to pay, it is talking in excess of about 56,000 crores to this one company. These are not national companies, they have sold their coal to power generating companies, power generating companies, that the solicitors told your lordship on. So water liberation. So if this company and this company, the other consequence which concerns, which must concern the court is, in some of these companies, the demand will be multiple times their net worth. The bankruptcy law doesn't apply. These are public sector undertakings. You will have the ugly spectacle of these companies just going belly up. If the governments insist they attach their properties, the companies won't be able to pay salaries, they will not.
Thank you, Mr.
So, this is only to paint the canvas, how wide the canvas is. And that is why certainty is more important.
Yes, 2 minutes, bro. I made a note and taking the cue from Justice Roy, I've given 8 reasons why it should be prospective. Yes. Yes. But most important thing is about this. Lordship has the nuanced approach. I got a paper by the Ministry of Mines which said in the aftermath of India Cements, several states lost substantial revenues. And then in 1991-92, the central government steeply increased the Section 9 royalty and the dead rent to compensate the states for the loss of revenue they would have suffered because of India Cements. So from the beginning, the royalties have been substantially increased. And Lordship knows that if even today, when I pay Section 9 royalty in Tamil Nadu, I pay it to the state treasury. It's a levy by the center, it goes straight to the state. So I have given that Ministry of Mines report also, where the central government was compelled to steeply increase Section 9 and Section 9A levies to compensate the states for the loss of revenue. Secondly, Lord, I have given in my chart just 10 cases, right from 11 judges, Golaknath to Indra Sani to everywhere. Every time there is a tectonic shift in the law, or the court is upsetting a provision which is made for 20-30 years, And whether Golaknath or Indira Sani or synthetics and chemicals, they are given 10 judgments covering constitutional law, mining law, arbitration law, tax law. So the uniform practice is there, and Golaknath, Justice Subbarao puts it beautifully. He says your lordship sitting on a bench of 9 lays down the law, but you make that law apply for the future because you want to ensure a smooth transition so that past transactions are not affected. Lordship, I have given the note first, paragraph 49. It's a very nice paragraph by Justice Subbarao. He discusses the entire law of the US, how prospective, map of Ohio and linked, etc. The sunburst doctrine. Yes. So that's the point. The other point I wanted to mention is one important point now. I read the judgment in detail. For the first time around, I think there is a comprehensive discussion on the interplay between entries in list 1, that is 2354, and entries 49, 50, 54 in list 2 for the first time.
Giving enough material for your new edition of the Constitution law.
But in fact, on a serious note, I just told him we have to rework entire Schedule 7 now. Thanks, Your Lordship.
9 judges partially modified 7 constitutional benches and 7 judge benches.
Mr. Data wrote a letter to me seeking to be recused from the Senior Advocates Designation Committee. He frankly said that with my book coming up, I have no time for anything else. So I think with this judgment, you might have to extend that sojourn away from the court for a little longer.
You have to postpone the budget. So, yes, thank you, grateful. But on a serious note, Lordship has really not considered the interplay of various things. About this dissenting opinion also. Now, most important thing is, these laws were held to be legislatively incompetent. India Cement said states have no competence. Now your lordships are restoring competence for the first time in 2024. So from 1990 to 2024, and with great respect for Lord Kesaram, whatever it does, Kesaram cannot override India Cement. That will be very, very clear. We should not send a wrong message that tomorrow a 9-judge bench, a bench of 4 will say, no, there is some mistake, I am nuancing it, and that applies. 7 is 7, it has to be followed. Tamil Nadu they followed, didn't make any new law. But Lord, Sundaramaya's case is important now, Lord.
Yeah.
Lord, the Odisha Act is 2005, Jharkhand was struck down, West Bengal was partly upheld, etc. Now in Sundaramaya's case, they say, if a law is struck down for legislative competence, it does not revive. He makes 2 distinctions, law struck down for constitutional prohibition and law struck down for legislative competence. And Justice Venkatramayya says that if it is struck down for legislative competence, it will not revive, it has to be reenacted. So that's the reason why it has to be prospective. Now states will necessarily, because the 2005 law was based on India Cements and other laws. Now very important, your lordship has completely redesigned the constitutional topography of all these entries, how to interplay both and so on and so forth. So I am only submitting in light of the Sundaramaya, it will be prudent for the states now to make a fresh law keeping in mind these.
That's very
But only I'm only saying that we have to be conscious of that fact.
That is on the principle.
One thing I want to say.
If a law is struck down judicially on the judicial side, and it cannot be revived judicially
Yes.
by another order.
Yes.
What has been struck down, it goes as voice.
That is what
More academic than practical.
Not expressing, that's exactly the point of the Article 39B and C.
Exactly, my lord. Therefore, my lord, I was also avoiding that argument. Lord, that's more an academic argument in this matter for this limited purpose, my lord.
And so, my lord, is it that Bombay rented matter, which your lordships are now going to decide?
Yeah,
Yes,
yes.
you decide. But this judgment holds, my lord, that what is dead and buried on account of legislative competence not being there cannot be revived, and therefore will have to be a fresh institution. If it has to be fresh, it has to be today, after the lordship.
But that's not the issue right now. Also the issue.
And that's the precise point on which there is a
The
judgment.
lordships have resolved the judgment. So give assistance.
Article 31C, etc.
And one thing I want to add, only one thing. Only one thing as a matter of as a
That's okay as a point also.
yes.
We are saying that Let us reserve something for future generation of lawyers.
Let's hear now.
One line you also may note.
But the last
The
point,
Odisha Act was enacted on 1/2/2005. Just note that date. Odisha Act, my lord, was enacted and became operative on 1/2/2005. It was struck down, my lord, on 5th of December.
Let's not go state wise.
I don't know.
Yeah.
On 5th of December 2005. So it lived for 6-7 months. There were no demands. There was no demand under that law. And my lord, it was declared unconstitutional, which is now being sought to be revived. Now, this is Odisha's position. Some states' position may be, my lord, hybrid, some way, midway, etc. Therefore, it is best not to go, my lord, into this situation, because some states will say, while we were, my lord, placed in a position where some money was paid, somebody will say less money was paid, somebody want a refund. So let's not, my lord, apply this principle. The lordship judgment is for the whole country. Therefore,
Are there any interim orders requiring a deposit plus a security for the balance?
not for Odisha, there are in one or two cases, there is an order of deposit of some part. Yes.
Okay, let's hear
Only one line, Lord. Economically, only one line, Lord. I have compiled
the reason for I'm only requesting the lordship can submit to all lordship approval. This is the problem we constantly face. By judgment declares the law unconstitutional or uphold, but there is no direction to give it profit or not. I'm saying on an important case, like for example, lordship with arbitration matter on stamp duty. Lordship said that law that necessarily has to go back. Because lordship is curing a problem, but if lordship is completely rewriting the law.
Okay, let's hear now.
only one line, Lord. Only one line.
The past becomes uncertain, which is not conditional.
Lord, only one line. Lord, we have compiled 63 judgments where your lordships have consistently applied, Lord, the doctrine of prospective overruling, which is annexure A to my note, which is already filed and circulated.
Let's see.
I have given it's a paragraph with the extract. So what should just see with annexure A. So what should we not go through all the book?
Yes. Yes, Mr.
I think the advocate, learned advocate general of Odisha wants to say something before I close.
Let off. We have a very specific.
Yes.
Yes. But as your lordship knows, this Odisha Act is basically in tune with the social welfare measures. And Odisha's population, mostly these mining bearing areas, are scheduled tribes because we have 9 districts as the scheduled areas. So the socio-economic development of the state was of paramount consideration, for which this 2004 enactment was made by the legislature. So the rule was framed in 2005. I have a very specific stand. I have prepared a small, these are the notes which I may pass on in course of the day. Mrs. Minister will pass over. This while implementing the provisions of the rule, we have to keep in mind certain subsequent developments by way of legislation, 2015 amendment, some ad valorem royalty.
Unfortunately, in Odisha, the act was brought into force with effect from 1/2/2005.
That is correct. That is correct.
And it was struck down 1/5/12/2005. Is that correct?
Right, absolutely.
Now, what will happen after 5/12/2005?
Because there was, after the legislation was struck down,
It was struck down.
that's,
And
it was struck down.
following India's cement.
Right. So after that, because there was no interim order here, so we could not proceed further. So it is as it is. But now subsequent laws have been enacted because this MMDR Act Amendment 2015, some royalty cess imposed. These are the 4-5 bullet points which I have been instructed to submit. So while implementing this rule, 2005 rule, we have to keep certain subsequent developments in mind, like introduction of ad valorem rate of royalty since 13th of August 2009. So this is they have said, so I have to introduction of auction for allocation because 15
royalty with respect from?
royalty since 13th August 2009.
Yes. Second.
So second is introduction of auction for allocation of the mines, that is by 2015 amendment, and this is auction premium is an additional payment also. The third is introduction of provision for collection of the DMF, District Mineral Fund, that is also basically meant for the taking of the social welfare measures.
No, these are collections over and above section 9. So we are not really concerned with this one.
So
Right is sitting in the middle, not on the side.
But if we go state-wise on the lighter side, state-wise, Madhya Pradesh and Rajasthan, I had a talk with their councils. They say that we have taken a pro-citizen approach. They are also supporting the prospective overall.
Okay, let's see that.
But that hardly not.
now at this juncture, you will have to know the state economic is bleeding.
Then that's the third. Anything more?
And the fourth is introduction of provision for collection of payment of national mineral exploration trusts, because these are the two funds which would be basically the purpose would be utilized for the benefaction of the.
Do you have an estimate in Odisha? How much did you realize in
That we have
ad valorem royalty? Then as a result of the additional premium which was the liability paid for after 2015, then the DMF and national mineral exploration.
That I have to work out because that data, that calculation is not yet made because I have to seek further instruction for that. So, but the legislation was basically meant for that, for the socio-economic development of the rural sections of the society, basically the scheduled areas I pointed out. So these are the more specific.
So what is the position then of the state of Odisha that the government should apply and solve for without being made prospective? What is the bottom line?
That's correct. That's correct. The bottom line is we have to basically work out what would be the total implication because the rule is to be.
You're not supporting the plea for prospective, the prospective
So
application.
if I say prospective, it would be a burden on our exchequer. Exchequer would be losing substantially. So basically, the economy of the state is in shambles now. We have several commitments for the socio-economic development.
Honorable Chief Justice is, whatever instructions about the correct stand you should be taking before the court.
So
Decide on that.
correct stand exactly they have not specified here. So this is the stand I have to work out.
Odisha, you have to lay your, you have to lay bare your,
Actually, frankly speaking,
because your first 4 points which you referred to indicates that, well, you realize something more thanks to the amendment. The second point, namely the 9 scheduled tribe districts, etc., seem to suggest that give it, implement the judgment as it stands.
that's correct.
So now, within these two, where do you really place for us both the submissions, one on this side, one on this side, which is the submission which you are now adopting as a state?
That actually,
Don't pass on your dilemma to the court.
right, no, it's not exactly.
You will decide what to do ultimately. We hold the balance, but you have to tell us where you stand.
And I have to first, because this judgment is report making. Now it has cascading effects everywhere. The learned Solicitor General also submitted. So I am not going into that in detail for the time being.
But are you supporting that or are you not supporting? You have to tell us. Now that you are very, we hold you down to a.
Now the scenario has changed in Odisha, your lordship knows. There can be contradictory stands. So, but
Therefore,
This is not the way.
Therefore, going with the general, are you?
and I have to protect my exchequer, whatever maybe because we have some.
Right, everyone is protecting everyone's exchequer. The question is whether windfall, which is ultimately being shared by the common man, should be acceptable or not. That's all.
But a common man should not be to suffer because of.
So thank you, sir.
I'll pass on a note. They put 5 points.
Just wanted your worship had put a question to the learned advocate general. What is the royalty received by the state government? Not as I just
That we have to work out. We have not.
26,000 have been paid.
That we can say now because I have hardly put in 3-4 days back. I assumed office, so we have not worked out also on that so far. So state by private budget.
A question to the learned advocate general as to what is the royalty paid? Just one company, that is Mahanadi Coalfields Limited, has paid in lieu of royalty because Mahanadi Coalfields doesn't pay royalty. These are all acquired lands in lieu of royalty from 2005 to 2006 to 2022 to 2023 is 26,141.63 crores.
Just one company.
Just one company.
But they did not say refund, that's all.
But this is all in lieu of royalty.
But that's okay.
There's no question of refund. This is because we don't pay royalty.
The money, that's all.
But this is over and above section 9 and 9.
This is not a.
No, sorry, Mr. Nada, 9 is not paid. This is in lieu of 9.
Yes.
Yes. So I want the judgment to operate fully. And I'm against any declaration of prospective overruling. I'm not against the authority of this court not to direct prospective overruling. Golak Nath and onwards, there are numerous judgments, as the learned counsel say, where the power of this court to make its own declaration in view of change of law, prospective, that's not being disputed. Issue is when it should be made prospective and when the court should not make it prospective, or even while making a decision for molding of relief, it's not necessary at all to make a declaration of prospective overruling. The lordships can let the judgment flow with full effect and at the same time impose certain conditionalities based on which the judgment or the declarations of law would follow. The second law in the instant case is a more appropriate course of action. Now, all these judgments, India Cement, Odisha Cement, Somaya, Synthetics, etc. They are right, there are about several dozen cases. They are in the context of a change of law which results in the enactment being declared ultra-virus. In synthetics, the change of law, that is the overruling of the judgment in HRS Murthy's case after 15 years of operation would have led to the states refunding the entire collections, which over the course of years the states spent in exercise of its sovereign powers. So therefore, these are those cases where they said that, all right, the law is rendered invalid because of our declaration, but we are imposing a condition. The judgment will operate retrospectively, but there will be no collection, no refund. So this no collection, no refund, which my learned friends on the right are clamoring for, that is all in cases where the new declaration resulted in the declaration of the operation of the law as ultra-virus. There is no judgment of this court where the change of law results in the validation of the act Taxation Act, and yet this court says don't collect. There is one judgment of 9 judges judgment, my lord, where my lord the Chief Justice was the party, that is in Jindal Steels. Entry tax. Thali did collect, my lord. Judgments 50-year-old were overruled. Atyabari, Khairbari, automobile, all overruled. But the declaration was not made prospective. There is a rationale for why it was not done. And why likewise in Keshwar Hamlers, also it was not made prospective. There is a rationale behind it. The rationale is this, that if you make the law prospective, let's say in the instant case, pure and simple prospective, nothing more. What would be the consequence? That either India Cement or Keshwaram needs to operate then. There can't be a vacuum in the past. So Lordship will have to decide whether this 5, 7, etc. I would say that once the Lordships have upheld the dictum of Keshwaram, then to say that India Cement will operate till yesterday would mean that all the laws passed by the states which are under challenge, including those which are founded on the pattern of the law upheld after West Bengal's law was upheld, then many states would have passed, just copied that pattern and enforced their laws. They all will have to stand the test of India Cement. Because your Lordship's declaration is post facto. So, the intention would be that judge our laws. Your Lordships have yet not declared our laws valid or invalid.
So if we hold that our judgment is prospective, then really speaking, possibly could be argued that those laws are invalid.
Invalid because India Cement comes in the way, gets struck down.
Until we deliver the judgment, the law was as it stood in India Cement.
So now that would be a travesty of justice, not if I don't use the term absurdity. It will be a travesty of justice that the law is this today, but our laws are struck down because of India Cement.
Which law is my
Which law? Which law you know?
There is no law.
Hold on, which law? There is no law.
Giving the judgment prospective effect, therefore, will seriously impinge on the laws passed by the state legislature, which would otherwise be valid on the test which we have enunciated by the majority.
That's right. Our law is of 1993. Jharkhand. I don't know. I don't know. On 22nd March 1999. In between, probably there was some interim orders or something. But I'm not on these interim orders, etc. The question is, if you make it pure and simple prospective, and only no refund and no collection, something which was in a contra situation directed, namely, even if we are suffering invalidity because of the new declaration, still no refund.
We make it prospective. The registrar has not argued for prospectivity per se. The registrar has argued on the second aspect, which you said that do that, that's much better.
With respect to solicitor says prospective, but no refund, no collection.
He said, and you are saying conditionalities is much better.
I'm saying, therefore, please don't go and use this term prospective.
Right. You got the point. Now, look at it this way. Another thing which you have pointed out, if we say prospective, then in any case, for the period prior to our judgment, you will have two decision. You will have India Cement, which is of a larger bench, and you will have Kesoram, which is of a smaller bench. Now we have on first principle.
So for that's why,
Kesoram line.
that is why they say that India Cement is of 7 judges and 5 judges, and therefore India Cement should continue. Your Lordship will have to now, having rendered the judgment, now your Lordship will have to say, not Kesoram, India Cement will operate till today.
So we have expressly held that India Cement.
That will be again, Lord. So we are entering into a whole lot of.
But Mr. We got the point. The jurisprudential ticket which will arise.
Yes.
But short of that, if you are to, because your second point was without prospective overruling, the court may impose conditionalities.
That's why your Lordship, Mr. 142 Lords is not a one toolbox. It's a toolbox with many tools.
We'd like a little bit of assistance from your side without really conceding. You are appearing for the state of Jharkhand. You're not asking to, you're not going to record it as a concession, but we are now looking at you as an officer of the court.
Yes.
Person, standing who we look up to for your assistance. Just to their rendered assistance. What kind of conditionalities can the court contemplate?
Lord, notwithstanding the instructions not to concede, I told them that I will not.
Mr. Very as we are putting you in a little bit of an embarrassment, but
no, it's a privilege to be an officer of the court.
Somebody who is assisting us on a fundamental issue of constitutional law.
No embarrassment. No embarrassment, Lord. It's a privilege to be addressed as an officer of the court, which we are always donning that hat. We never shed it. So, now there's another aspect. A lot of things have been said about the impact orally. There is no affidavit before the Lordships of any of the barring sale, which has mentioned in its affidavit that there is some huge all over the states. So now they.
But the rent of debt outstanding.
At page 813 of KanoonPlus, though overruled in Keshwan and Bharati, but this principle has not been overruled in Keshwan and Bharati. So it continues, Lord, and has been used by this court as a tool. Whenever ends of justice require, look at page 813. Some poignant observations. Court says it is really a pragmatic solution, reconciling the two conflicting doctrines, namely that a court finds law and that it does not make law. It finds law but restricts its operation to the future. It enables the court to bring about a smooth transition by correcting its errors and without disturbing the impact of its errors on the past transactions. It is left to the discretion of the court to prescribe the limits of retrospectivity. So this is what I was relying upon to say. And in subsequent lordships have said that there are so many variations. It's not a rigid doctrine. It has enormous flexibility, which is indicated by the phraseology of Article 142 itself. When combined with 141, 136 and 132 minutes. Then again at page 814.
Really, democracy means subject to, of course, I am considering the submission. No question of prospective overruling in a situation like this. I'm not discussing with my learned colleagues. We'll all sit down together and. But the question is that, as you rightly said, that even if you don't give prospective effect, you have to. The court does have the power to balance the conditionality. What will happen for the past period? One, no refunds, whether the states have to, there can't be any refund now because we have upheld the power of the states. So no question of refund. If we were to make it prospective, then the question would arise because those laws would still be, somebody can argue those laws are invalid on the basis of India cement. So the state has to refund. Once you have said that the states do have the power, there is no question of the state being required to refund. Question is about the new demand because for the past period. Because we can't be also oblivious to the fact that, from 1999, in your case, the law was struck down in 1999. There is no demand, 24 years down the line. So, should we contemplate a situation where 24 years later, there will be now demands on the company, many of whom are public sector companies? That's something which you have to put to you.
No, it's not that I'm unconscious of that, but
the law India Cement, 7 judge, Kesaram, 5 judge, with this particular judgment of the 9 judges, a clarity on the law is laid down. You are trying to say that it should have effect retrospectively, but you are referring to Golaknath saying that the pragmatic view is to be taken. Now, the concern that is being raised by the other side is on the financial implication if either of the view is taken.
yes.
Now, we have to be a little conscious of the financial implications, not only financial implications, the commercial contracts, covenants that have been entered, domestic or international. Now, lot of those disturbances are likely to happen. Of course, the financial implications are also going to be of considerable.
So, if your lordship,
You have to assist us in the way of conditional
Conditionality.
conditionality, as you have said.
so my broad effort is to request that your lordship balance the two laws. Not if you look at simply about the cascading effects, the huge amount to be paid, etc. There are other ways of balancing it. For example, if you have to pay 500 crores, let us say, assume for illustration, that can be staggered. You pay arrears every annum, 50 crores, the next 10 years it will be paid off. So this implication and huge burden, etc. is not something. One thing is to allow them to pocket it. Don't pay at all. The other is to stagger it. The better course is to stagger it as much as your lordship finds reasonable. 4 installments, 8 installments, which lightens the burden. Prevents the cascading effect. That's the only impact which they have voiced. Your lordship, second thing your lordship can do is that, for example, in our case, it's not a tax on minerals. We have imposed a tax at the rate of 1 rupee per square meter on the land. Whatever you may extract and sell, we have nothing to do. You have this much of lease land. On that land, we have imposed it, so it's a fixed per annum. And so far as sale is concerned, which has filed affidavit, the entire burden is about 454 crores. What? Please.
Answer.
maybe staggered, the demand maybe staggered over for.
Just allow me a little leeway.
Would it be possible for the court to also prescribe conditionalities that will be a certain proportion of the demand for the past period to be paid?
So I'm just providing some more. For example, now under our act, there are two kinds of lands, or rather three. One is mineral bearing land, the other is industrial land, and the third is commercial land. So it's not only mineral bearing land. Now sale out of 454, 430 is industrial land. It has nothing to do with India Cement, etc. Now why should not, therefore, if their whole basis is India Cement, why should the industrial land and the commercial land not be given that benefit? This can only be limited to mineral bearing because India Cement was confined to cess and royalty. So on their own submission, the conditionality should be limited only to mineral bearing land, even the staggering part. As far as the rest is concerned, under the Lordship's dictum, restitution is the normal principle. That if you have relying on an erroneous judgment of the High Court, you can't say that this court has.
In relation to land other than mineral bearing land, there is no case of what.
There is no case of what. It has to be limited to mineral bearing land. The third thing is.
Yes.
So there are only 6 mineral bearing land SSEs. 18 are industrial or commercial. They all want to ride on the shoulders of the mineral bearing land, India Cement. This controversy of 5-7 doesn't impact them. The third thing which can be done is under the Act and the rules, the rate of interest is 2% per mensum simple interest, which really comes down to 24% simple interest. So the bulk of the demand, which they are saying 60,000, 70,000, is on the interest component. As usual, their demands are not that much, but since 20 years, 30 years have passed and the amounts were not paid, therefore that component will go up. That can be more suitably tackled.
No, are you correct? Is our understanding correct that the figures that have been cited by the other side has the element of interest added to it?
Yes. Although I can't say none of them have filed affidavits. They are all just trotting figures which we don't know.
Interest is something which certainly the court can.
Yes, but in my submission I have annexed the statements of each company. I have given the statement, interest also I have given. And the Lordship will see from that chart that the interest component is really for example, sale lot is 558 crores demand over this 30 years. But interest is about 1,000 crores or something. More than that. Now, so if that is not suitably modulated, it will reduce their burden. So we are here for balancing. None of the petitioners have talked of balancing. No collection, no refund, ultra-virus cases. We are here in an intra-virus situation. Normally, in view of Article 265, once a law is passed, nobody can say that don't collect the tax. But the Lordships have got this special power under 142 to modulate depending upon a particular situation. Otherwise, ordinarily, your Lordship will never do this, not that the law is valid, but tax, don't collect the tax. But let me take, my friends must have calculated, I'll take them on their words, so that I can also visualize that there will be some effect, maybe cascading. So this is how it can be done. This is not, we need not adopt the ultra-virus situation here and say that no collection, no refund. That's very convenient because nowhere they must have paid. the proceedings what
Come down to now change estimate.
because somewhere even here lordships have said no interim order rejected. I have annexed note in my every case. Barring Odisha, Bihar and Jharkhand. In Andhra Pradesh, stay rejected. This is another vital factor. That once the stay was rejected and High Court you lost, then you should have collected, you should have passed on. If you have not passed on, then you have willingly not passed on. And the law on tax is that passing on is your discretion. Not a law.
What happened?
There was no law. There was no demand. State-wise, we have to say many things.
Take the state by
State act-wise, we have to say many things.
mineral bearing land. Odisha is all mineral bearing. The act was shut down in 8 months. Not a single penny of demand was raised. We could not collect. We could not collect the passing.
Situation, my lords. 2005, a cess was levied on minerals. My lords, while entertaining the challenge to the cess, the High Court declined to grant an interim stay. In 2007, this Honorable Court gives an interim stay on the operation of the cess. Till date, the Act continues to be on the books. Therefore, my lords, in my humble submission, an Act which continues to be on the books, the question of prospectivity or retrospectivity would not arise. Only the operation has been stayed by an order of this Honorable Court.
Shut down in Andhra Pradesh.
Never. That is why we are on a factually unique footing, and I just want to point it out.
Now, Madhya,
Yes.
just a minute.
We have to say much.
You say much. Nobody stops. Please. You are interrupting.
State-wise, because
State-wise, you say much. The architecture of every act is different.
What we should do is, we lay down broad conditionalities, that which is within our power. We will of course reflect on it. But what Mr.
Just allow me to finish.
I want to say something.
Let's not, 1 second, Mr. We will finish in 2 minutes now. We let him. Yes, Mr.
Now, Madhya Pradesh, Lord, High Court upholds no stay. Rajasthan upheld no stay. Chhattisgarh upheld no stay. Chhattisgarh, they said you have to pay subject to the outcome.
Are these now in entry 49 or entry 50?
So there are many things. State-wise, we have to say many things. And Madhya Pradesh and Rajasthan have taken a pro-citizen-centric approach. They do not wish to collect the past.
Who prevents the states not from passing a law tomorrow and saying that don't pay? It's not my argument that after Lordship says it will operate as it is. Then Rajasthan is certainly free to pass a law and say they will not correct.
Or they not raise demand.
Don't pay. If Odisha doesn't want to give a concession, it can certainly do it. So what is the problem in the states?
So Madhya Pradesh High Court upheld the law, no stay. Rajasthan upheld the law, no stay.
UP no stay.
Sorry?
UP no stay.
Which law was that law?
So the point is, what I am saying is, West Bengal, Kesharam upheld, and right from 92 they have collected tax. All areas were paid fully. Heavens did not fall. No industry sunk. All these people are there in Bengal also. Why don't they produce their balance sheet, etc., to show not how much is that 61,000 crores is the turnover of sale?
So really, if we go into the states, it will be a never-ending inquiry.
No,
I'm not saying
it's different.
My
reason for setting aside is different.
The provisions of those laws which are serving.
I'm saying
Whether
something else.
under 49 or 50, that also not is an issue.
I'm not requesting your lordships to go individually into the acts, not at all. What I'm saying is that look at the discrimination which will happen. West Bengal collects, other states rejected. Now we say don't collect. best course, therefore, in the circumstances of this differential situation, the 9 judges judgment have accepted fiscal federalism. So, because of some state, etc., another state can't say. This richer state may say, we will not collect. A poorer state may say, we need the money. We are not able to pay the salaries and the pensions. SLP is pending in this court for paying of pensions. So, ultimately, please balance. That's my bottom line, which I'm trying to convey is that please balance. It's not only their problem, it's a problem all around. So the proper balance, therefore, has to be, in my respectful submission. The first submission is that please stagger it, tackle the interest, that will reduce the burden drastically and make it comfortable to pay. So I'm not saying go into individual cases, but look at the situations where some state collecting, other state, some has collected, other state could not collect because these differentials therefore can't enter into the melting pot. Now the other thing is that supposing this doesn't find favor, then the other alternative which could be thought of is that right, wrong, whatever, whether it was proper or not, Kesharam made a change. Now Kesharam basis Bengal collected, other states make their laws, etc., which are under challenge and now not likely to be upheld. Therefore, that can be another cut-off point. Plain and simple, do nothing and just this.
The date of Kesharam?
That is
15 January 2004.
2004.
15 January
2004.
Yes.
So which instead of 30 years or so, it will be 20 years.
Payment is dated
1991.
25th October
1990.
25th October 1989.
So along with that cutoff date and something tackling the interest, that is a neat and clear. And then our judgments, acts will be tested on the basis of your lordship judgment. That's my humble submission.
So there are three benefits according to three benefits. One, stagger the payment, so delete the interest and take Kesharam as the cutoff.
Can be combined or alternative. I would put it as I'm leaving it to your lordship.
Respective areas, in commercial approvals.
Yes, I'm appealing the UP matter, Lord. Facts are very startling, Lord. In the UP, the High Court has upheld the levy on 1st of March 2000 in Ramdhani Singh. Matter is carried in appeal in Kesharam, and in Kesharam, judgment is upheld in paragraph 134 to 148. So far as UP is concerned, there is no question about it. Lord, the levy is valid since beginning. And Lord, the entire premise is based on that India Cement is holding the field till 24th of July 2008.
You raise demand and were they paid over to you?
Lord, two of the industries have come to your lordship. They filed a writ petition, my lord. Subsequently, they filed a transfer petition and matter remains pending. Only two, Hindalco and Kanoonplus, my lord, has filed the transfer petitions.
But your levy was upheld by the High Court.
Have upheld by the High Court and Supreme Court specifically deals with it and upheld it. Lord, we have collected
on Hindalco and the other.
and yes, Lord, Hindalco and Kanoonplus Chemicals are the two persons who have been holding it, Lord. All others must have paid. So where is the question of two industries, Lord? Because they choose to file a transfer petition, get a Lord interim order there, ex parte, file a transfer petition, High Court proceedings remain pending, and they don't. And we who said Lord, they have not collected, not passed on. There are no facts, Lord. 142 is very important. Lord, what your Lord said in 142. Lord, what your Lord
I'm so sorry. Lordship says 142 lordship balance the equities to do complete justice in a causal matter pending before it. They must plead and prove, my lord. A bold statement. My lord, one more thing, lord. The entire premise is based on that India Cement is holding the field. My lord, India Cement is not holding the field. My lord, since 15 January 2004, please. 15 January 2004, Kesoram is holding the field, my lord. Last 20 years, my lord, right, wrong, your lordship has decided. But what is holding the field is not India Cement. What is holding the field is Kesoram, my lord, from 2004. And my lord, finally, one more thing, my lord. Court have said, my lord, Blackstone famous dictum that court finds the law and does not make it, upholding Goraknath. Retrospectivity is the rule, my lord. And my lord, prospectivity is only an exception. They must take out the case an exception, my lord. Please, lord.
I recommend and my privilege for the state, for the state of Jharkhand, and I have not made submissions on the last occasion because everything he has appeared for the appellant, that is an authority created by me. I just wanted to point out something. I just wanted to, not more than 2 minutes.
All right.
Yes. There's two aspects which may bear consideration in regard to prospectivity. Is that whether the enactments pursuant to the reference having been answered would hold the field or they are struck down. That is covered, my lords, that the enactments most likely would hold the field because our lordships have acknowledged the right of and the competence of the states to frame the laws. The other aspect is the molding the relief at the behest of whom? Molding the relief, your lordships have always done at the behest of the party who has successfully discharged the burden while attacking the legislation. The parties, there is one aspect in the last order which I wanted a correction. The appellant's word has been used while your lordships pronounce the order. We are the appellants, we are not asking for prospectivity. It is the SSC companies basically. Yes, so therefore,
procedural order that we were listening it for today.
Yes, so therefore the other aspect which I wanted to just highlight, which your lordships have taken note of, is whether the burden has been successfully discharged by them. And can they ask for molding of the relief? The other,
Can I get only 2 minutes? By the law,
I want a very broad notice, sir.
I want to.
Yes, 2 more points. What
4 points. The other is the common man effect, which my learned solicitor argued. But the money which comes to the state's coffers is also meant for the common man.
And what else?
And third, my lords, the power to make laws and power to implement them are also in the domain of the legislature. So if any of the states wants, yes, and
I only want to,
let's go.
I only want a minute.
just one order which I wanted to point out, lords, because this is very crucial. The nature of the order which your lordships have passed at the interlocutory stage, and we have this is passed in IA number 3 and 4 in civil appeal number 4745 of 2006, and this is dated 6th of December 2010. This is by a bench comprising the then Chief Justice Justice Papade, Justice Panikar Radhakrishnan, and Justice Sarvendra Kumar. May I just read the order? It's a short, very short order. Very short order.
What's the date of the order?
The date of the order is 6/12/2010. I can pass on to the but passage is part of here. Third, learned counsel for both sides. We direct that each of the SSCs appearing before us to file returns under the relevant statute. If they have filed the returns, the assessing officer will complete the assessment by a written order in accordance with law. If that order is against the SSC should prefer an appeal in accordance with law. If any matter is pending before the appellate authority in appeal, the appellate authority will decide the matter in accordance with law. It is made clear that pending appeals, every SSC will pay the taxes without prejudice to its rights and contingencies in the pending appeals. So these are the nature of orders which your lordships have passed.
Notwithstanding the fact that the law was struck down.
Not be this group itself, other group.
This is from Madhya Pradesh. This is Jay Prakash Associates. No, I am just showing the nature of interim orders. Either it has been declined or there are no vacancies.
Therefore, it's not an interim order for Jharkhand. That's why I got it leaked.
No, not for Jharkhand.
I only want 1 minute.
The regular bench, but in individual case, they have to take.
We have to bring clarity. We are not going to go statewide. We'll pass general clarity.
In Jharkhand,
I only wish to say one thing. What Mr. Dwivedi is saying for his state relating to mineral bearing areas, that cannot be the rule otherwise. Without Odisha is only mineral bearing. Our act was struck down in 8 months. Not a single demand was raised. Care was gold. Maybe I did not collect, I did not pass on. So after 30 years or 20 years, to put this burden today, that I will not take it, pass it on to somebody else who has subsumed it. How will this principle apply?
Where are you appearing from?
We are for the Odisha industries. We are Odisha industries. There was never a demand, and when the government lost and came to the Supreme Court, there was no stay in the SLB of the state of Odisha. No stay at all. Not without half stay, will say. In the case of Odisha, without demand not raised and struck down in 8 months. No demand, no levy, no pass on. And no stay in Supreme Court. If this be the position, how can we be bulked with these demands today which we can't recover from anybody? And today by passing to a new consumer, it will be a double whammy for him. Because either the link is good.
Yes.
Only 2 minutes.
Nobody have one sentence. Well, there are 6 matters from Jharkhand High Court, Patna and Jharkhand. 3 decided pre-Keshavram, one way. 3 decided post-Keshavram, other way. That's all.
Only one thing, the conundrum which Mr. Dwivedi tried to create, which will be the law which will govern. We are clear, your Lordship's 9-judge bench judgment holds the field, India Cement goes. Nobody says that previous to your Lordship's judgment, the India Cement ratio should remain. Whether we use the expression prospective overruling or not, we are urging your Lordship's 142 power to mold the relief in peculiar facts of the case that this is not A versus B litigation, but the result will be felt by each and every common man of the country. So that is why your Lordship's power of 142 to mold the relief comes. So far as this distinction between principal and interest, without again naming the PSU, without interest, one of the major PSU has 35,000 crores without interest. Only the principal, and its net worth is 14,000. Net worth is 14,000, and the demand without interest is 35,000. Since it's a listed company, I am not naming the company. I cannot share it with your Lordships. But even if your Lordships may be persuaded to...
Now the demand of 35,000 crores, how much of it is principal and how much is
only principal. With interest is 55, but only principal without interest is 35,000. Therefore, I gave this figure, that this is not the figure inclusive of the interest. And the total net worth is 14,000. Now, even if we were to stagger and pass it on to the end consumer, ultimately the end consumer will be burdened. So we are not saying that till your Lordship have decided, let India Cement hold the field. That's not the argument. India Cement goes. Your Lordship's judgment is the only judgment which is the law of the land. Your Lordships can mold the relief that in Calcutta, miners have paid, mineral bearing land, they have paid. In UP, they have paid. Odisha, they have not paid. Therefore, I have said that taking a broader picture, since it is a constitutional issue which your Lordship settled now, that let there be a pan-India decision that now, hence, many a state where the demand, the act was sustained by the High Court, upheld the demand, upheld the law, but the demands were not raised. So there was no payment. Wherever demand was raised, there is a payment. So it
could be the language and difficult way to answer us offhand. If we take the cutoff as the date of the Kesharam judgment.
20 years?
No, it is more than 150,000 crores from 2004.
For private industries.
Yes. And I got figures of a large private company I am appearing for, I don't want to disclose it now, but it is in excess of 1 lakh crores. One of the further difficulty is this. The Lordship has now upheld the power under entry 49, entry 50. Lordship has said state has got full power under 49, plenary power. 50 subject to what limitation? Now today from 25th July, Lordships have held Raya Ramakrishna tax laws can be retrospective. There is no difficulty. Just envisage different states. Let us not go state by state. Suppose tomorrow every state has endless amount of money. It's insatiable because of the kind of commitment they have. Tomorrow, from 1st August, the state passes a law. You will pay retrospectively from 2020. Somebody will say from 2015. Then again, I was
2004 is also 20 years burden. Let's not go into the niceties or academic discussion. 2004 is also 20 years burden. And between 2004 to 2024, there will be several financial transactions which must have taken place. What your lordship is?
Of Kesharam. But was it correct for Kesharam to take not that kind of a view to explain 7? He said another issue. 11, 5, 7, explaining 11. We have this problem, but it can never be.
Manoj, can I just?
I will not explain by 5.
Manoj, can I just suggest 2 tests, Manoj? Manoj, can I just suggest 2 tests, Manoj? Yes, Manoj, can I just say 2 tests? Just 2 tests, yes. Yes. No, Manoj, your lordship, when the lordship 142,
Your last desire to do complete justice is the test.
Yeah, absolutely. The last 2 tests, lordship, when your lordships are discussing, please visualize what is the extent of disruption your judgment will cause because if it goes retrospective. And secondly, will it create liabilities which did not exist on 25/7? In some states there are states, but in most of the states there is no law at all. Except barring couple of states like UP and Rajasthan, my Jharkhand, in most states there is no law.
Like my
Please visualize. When your lordship judgment
to pay
for
something.
and the 2 tests, comes in.
And please don't give states ideas on retrospective legislation.
If your lordship judgment is going to enable states to create liability, it will be a retrospective liability. So my humble submission is, let it be a binary, not black and white. Let it be prospective. Royalty is not a tax from 25/7. Before that, whatever it was, it was.
We are not on royalty tax, etc. Levies.
You have a turn of phrase as we rise. Not a submission, but a turn of attention phrase.
Whatever one may say, we are talking about judicial retroactivity.
No.
You also have to manage that.
Everybody, I don't think anybody will have a feeling that we didn't.
All I said is please don't give states ideas like retrospective legislation.
The last word which I gave the attention on bench, I give the last word to my brother as Rishikesh Roy as usual.
Yes, we are also eagerly waiting.
Yes, certainly.
And one last thing, the judgments are more difficult to change because law we can challenge, but 9-judge judgment we cannot touch at all. Many years.
Enough.
This Oak said leave something for our future, so we can have. But justice.
What I could understand, very strong battles fought, and the expression used is from this side is that no refund, no demand. It reminds me of a similar war, but in a martial art field. No retreat, no surrender.
Yes. That is balancing equities.
Very grateful. Very grateful. Very, very grateful.